Hi, everyone, and welcome to today's Church and Ministry Alliance live stream. Welcome to all of our existing members in the Church and Ministry Alliance. We are so grateful for the opportunity to partner with you for the gospel. For those joining today who are not yet a part of the Church and Ministry Alliance, thank you for attending. We hope that you find today's conversation edifying and helpful to you. My name is Pat Piccolo. I'm one of the attorneys on the Church and Ministry Alliance. I'll be hosting today's conversation. I just want to open us with a brief word of prayer before we dive into today's content. Dear Father, thank you. Thank you for this day. Thank you for all of those attending. Thank you for the opportunity to have this discussion. We know, Lord, that the church is your plan. We also know that this moment in time, this moment in our culture, in our history, calls for faithful and prudent stewardship of the legal dimensions of the body of Christ. I pray that you would help guide this conversation, lead this conversation, that you would make it edifying to us and to all those listening, and that you would use it to bear fruit in your church throughout our country. We pray these things in your Son's name. Amen. I wanted to start by briefly describing a little bit about Alliance Defending Freedom and the Church and Ministry Alliance for those who are not as familiar with us. Alliance Defending Freedom exists to keep the doors open for the gospel. And on the Church and Ministry Alliance, we want to help the churches that are walking through that door to transform the culture with truth. And as I was mentioning in the prayer, we realize that this moment in time calls for faithful and prudent stewardship of the legal dimensions of the body of Christ. And on the Church and Ministry Alliance, we want to help you steward it well so that we can see lives transformed by the saving love of God poured out in Jesus Christ. We want to support you in your mission. Today's conversation has some simple goals. I do have to mention that the title of the live stream is a little bit misleading, admittedly. We're not going to really be talking about the three main challenges that are confronting the church, but really what we want to do is help your church assess three key areas where it's most impacted in its ability to operate freely and faithfully to live out its mission. So those three areas that we'll walk through are, number one, the bylaws. Your church's bylaws are an opportunity to develop your ecclesiology, to develop your religious identity, and it's really step one in laying a strong legal foundation for your church's religious liberties throughout all of its operations. Number two, employment. We want to talk about the good stewardship of your employment documents so that you can manage your personnel consistent with your religious mission. And third, facility use. How do you utilize your facilities in a way that ensures they're being consistently used to advance your religious mission and consistent with your purposes as the body of Christ? There are going to be a number of interactive tools that we're going to be using throughout today's conversation. The first one I want to highlight is the Church Readiness Questionnaire. This is going to help you identify gaps in your policies and also prioritize some next steps. You can find this questionnaire in the resources section on your screen. Along the way, we're also going to talk through some real-world scenarios. For this, we're going to use interactive polls. These aren't designed to produce a correct answer, as we'll talk about, but they're really designed to help you wrestle with these questions, think about them, and discern what is the best approach for your church, for your ministry. Just a couple tips on the polls as they pop up. Please answer them as they appear, and we'll show the results after each poll. For your convenience, the poll results are going to remain open until you close them using the X in the upper right-hand corner of the box. And then please note that the interactive poll will not appear if you are watching the video in full screen. Helpful tidbit there. I'm joined today by two colleagues, Don Zeal and Jeremiah Gallus. Don is immediately to my left here. He is the Senior Vice President of the Church and Ministry Alliance. And Jeremiah, at the end of the table, is Senior Counsel on the Center for Christian Ministries, where he helps lead the litigation efforts on behalf of churches, schools, and all of their Christian ministries. So thank you, gentlemen, for joining us.
Thank you.
We're going to jump in actually with our first poll question, which should be popping up on your screen shortly. It may take just a second for that to populate. When was the last time your church updated its bylaws? A, this year. B, within the last 5 years. C, unsure. Or D, never. And we'll go ahead and give you guys just a few seconds to answer that question. It's always an interesting one to me, especially having conversations consistently with churches. The answers can tend to be all over the map. And it looks like the bulk of our attendees have responded. And I'm not sure if I can. Well, it looks like almost the plurality of people have done so within the last 5 years. That was the most common answer, which is actually great.
Not too bad.
Great.
Yeah.
That's really good.
And I actually kind of wanted to start with just Dawn and Jeremiah. Do you guys have any thoughts on what best practices is? This is a question we sometimes get. How often are you supposed to look at these governing documents?
Yeah, and it's a good question, and I'm not sure. There's, like Pat said, there's not necessarily a right answer to any of these poll questions, but they can help us spur on some conversation. I think we use the analogy a lot of times when talking about bylaws of this isn't about. It's not like fixing an automobile. It's not like you're driving along, you hear a loud noise, and then something's wrong with your bylaws. It doesn't usually work that way. We use the analogy of a garden, typically. You've planted these, in some cases, we work with churches with varying degrees of history, from church plants and brand new organizations to ones with hundreds of years of history. And so sometimes those gardens are planted years and years ago, and sometimes they're relatively new. What we would suggest is, like with any sort of pruning, and I will say, the analogy fails a little bit because I am neither a car person or a gardener. So I'm gonna try to stick with the analogy, but you'll probably quickly find that my gardens would die very quickly. But in the analogy, we would say, there's a lot of things you have to do to keep a garden healthy. And so you need to do it, you need to look at your bylaws the same way, and you need to cultivate them like you would cultivate that garden. Pull the weeds, take a look. Culture is shifting. You guys are all experiencing this in your ministries. And so looking at those on a regular basis, usually every at least 3 to 5 years, if not every 2 years, where you're looking at that and saying, hey, what has changed? And what might the things that we spoke on or we put in here before, what has altered and what we need to look at? So a regular check-in that's consistent with that concept of pruning is what we would recommend typically.
Actually, I want to build on we don't have to build on your analogy, but I want to build on the concept you were pointing towards there. It's my understanding that everyone who goes into ministry, they do so because they love governing documents.
That's right.
They're most excited to just dig into the bylaws of the organization. No, in all seriousness, they're so important. And I think there's this tendency that is quite frankly understandable to view bylaws as, and really the stewardship of legal documents generally, as a mere administrative task, set apart and different from actual ministry work. And I thought it would be helpful, Dawn, for you to explain your reaction to that. How would you push back against that, and why?
Yeah, and I think that's a pretty common response, and it's in all of our lives. I think about paying bills and all the things that I have to do, to keep up with things, with business things in my own life. It's not what I wake up in the morning excited about. And I think that's absolutely true and completely understandable in the ministry. You're not looking at these administrative tasks as the reason that you got into the ministry. However, I think that one of the things we want to invite organizations to is to a paradigm shift on how they view some of their key documents, key policies, including bylaws. Just, to be clear, what we're talking about when we say bylaws, and it could look different and different. It could be a constitution. There could be some different ways to describe it depending on the type of organization that you are a part of. They're organizing documents. They're what sets up the authority structure of the organization, the rules which govern an organization. For churches and religious organizations in particular, it's probably going to include like a statement of faith, like where we root our theological beliefs and principles. How deep are we going to go in our organizing structure? Those are always questions you're asking. And if you think about those type of questions, it quickly takes you out of the mindset of this is just an administrative task into, no, this is a cultivation of our core identity. This is how we describe who we are. I think that the temptation is to say, just give me language here, give me magic words, because this bylaws concept is really just something I have to have in a file somewhere. And we want to encourage people to think in any of these, when we get into policies and things like that, these are not just to reside in a filing cabinet or in a computer folder, a file folder. These really are to be interacted with. They are to be truly governing documents, which means they need a lot of time and attention, prayer, and they need to be sincerely describing what you believe God has called you to as a mission.
Yeah, and I want to build on that for just a second. So obviously we want to talk about the legal significance of them and the legal impact they have, particularly on a church's access to constitutional liberties. But they're also a discipleship opportunity for the whole congregation. I didn't know if you could talk about that for a second, Don. Sometimes we see or experience maybe in our own churches and our own lives that the Constitution could be unwittingly shaping the way we understand what it is to be a citizen of the body of Christ, rather than the Constitution protecting our understanding of what it means to be a citizen of the body of Christ. And the bylaws are really an early opportunity, or one of the opportunities for the church to disciple the congregation in the meaning of belonging to the body of Christ. I didn't know if you could speak to that at all.
Yeah, I think I moved. I've moved a few times in my life, and the latest time was 3 years ago. And one of the first things we do when we move is we pray that God would provide us the place that He wants us to go to church and become a member and prayerfully serve that congregation. At that moment, I'm always looking to those set of documents to say, what does this church stand for? What is it about? What's God calls this church? What's made this church unique? And I think on the flip side, again, it's not just something. My expectation is it's not something they want to hand to me. And I've seen this done really well, where pastors can use this document and say, this unfolds what God has called us to be, and that could be for some churches rooted deeply in history. This is how God has brought this tradition along, and this is how we're going to do this, and this is what we call our members to. And if it's on paper, it's written there, I think it becomes an enormous tool of accountability, of conversation about the issues, of maybe bringing somebody who hasn't had a church experience to understand what it means to covenant together in this way. Your bylaws can I think serve you in that way if you're covering the right things and you're talking about the right things and you're using them in a way, again, of this self-description of this cultivating a Christian identity in the documents that you have. So they're not tucked away. They're there to be brought out, to be interacted over, to be calling people to the mission that the organization is called to.
That's great. I think you've already touched on this question a little bit, but maybe just to draw it to the forefront a little bit more. What are some things that are really crucial or very important for a church to ensure it includes within its bylaws? And I guess related to that is, what's the risk of having generic bylaws that look like any nonprofit corporation? I think those two could probably go together.
Well, and we'll get into the legal risk a little bit too. So again, I think the first question is, you want to be looking at this from a mission perspective, biblical foundation perspective. When we start talking about legal risk, one of the phrases, and Jeremiah will certainly mention this as we start talking about some of the nuances in the law, is one of the most important things in legal protection for religious organizations is that they're presenting and they're being consistent in following their sincerely held religious beliefs. So the problem with just grabbing language from someone else, letting someone else do the work for your organization, is that you're not necessarily putting down what is true of you. Now, there's obviously enormous ways that we share language. We share traditions. There are churches that are coming from the same denominational background that are going to adopt the exact same document. There are churches that come from the same denominational tradition that are going to adopt very similar language. But that shouldn't then take away from the hard work that's done at the local church, at the local organization level, to say, what is it that God has called us to, and what are we going to put in this document that is so core and foundational to why we exist, that if I was ever called to question on these things, I would say, this is what I sincerely believe. This is truly what our organization stands for and can carry out. And so you don't want to let someone else do that. If you just take the language and apply it, now you might want some help on some different things, but if you just take blanket language and apply it, you're in essence giving up the pleasure of being able to go before the Lord and put down on paper, whatever that community of people who are doing that, what the Lord has uniquely called you to.
That's great. And I think that's a good segue into the legal significance of these. So Jeremiah, you litigate on behalf of churches. Can you explain a little bit more the legal significance, or how well-crafted bylaws can lay a strong legal foundation for churches?
Yeah, absolutely. And the first point I'd like to make is really just picking up where Don left off. It's just this basic, practical, common sense point. If you want to protect your ability to operate consistently with your religious beliefs, you have to articulate and define what your religious beliefs are. And it's best to do that in writing. And it's ideally, you're applying those religious beliefs to specific situations as well. And the reason that's important is you as pastor, ministry leader, might know the answers. You might not know the answers to all this, but you more than likely know the answers to what your religious beliefs are, how would they apply to specific situations, but everyone within your organization might not have the same level of clarity. And so you can't assume that those working within the ministry or organization or church are going to understand how your religious beliefs apply to the wide variety of hypothetical situations that could arise. And so you want to ensure that consistency. So being clear about your beliefs is a gift to your employees and helps protect your religious freedom. Now, the second point is, when the rubber hits the road, when there's a legal challenge that arises, whether you're facing a lawsuit or some sort of government action that's threatening your ability to operate consistently with your faith, Don mentioned this, the religious protections apply only to sincerely held religious beliefs. And so your written documents that articulate your beliefs and how they would apply, that's exhibit number 1 in any litigation. That's the main evidence as a litigator we're going to be pointing to explain, here's the religious beliefs of the church or ministry, and ideally it's explaining why they can't do what they're being asked to do, or why they did what they did in the first place. And so it's the most important piece of evidence in any lawsuit or potential litigation.
Do you have any examples of that gone wrong or gone right from actual litigation, actual court cases? Yeah,
so the examples of it going right are numerous. I mean, basically any First Amendment free exercise of religion case that turned out the right way, that involves an entity, a church or religious organization, the court is relying on written documents to explain what the mission of the church is or the religious ministry, what their beliefs are, and how that creates the conflict with the law and therefore triggers the religious liberty protection. So, I mean, the case law reporters are just full of positive cases. Now, to give an example of negative cases, there's certainly those too. One that comes to my mind is a case that was fairly recent that involved a Christian school in California that had a tackle football team, a boys tackle football team, and they faced a situation where their boys tackle football team was going up against another school that had a girl who was playing wide receiver. And they did not feel comfortable in allowing their boys to engage in that level of physical contact. It's a violent sport. They did, as a matter of religious principle, didn't feel like they should have their boys do that. And so they didn't participate in the game, and they were sued. And the student, the female student on the other school's team, alleged that the religious school violated Title IX, which is a federal law that prohibits schools that receive federal financial assistance from discriminating based on sex. And so she brought a lawsuit saying this was sex-based discrimination. And the school did its best to try and articulate and explain why, as a religious matter, it couldn't do what it was doing. And what the judge said there was, well, you have this policy that prohibits physical contact between boys and girls, but you haven't explicitly linked how that policy ties to your religious beliefs. And so the religious exemption that's available in Title IX, I can't say at this stage of the case it applies, and it allowed the case to move forward. So that's a very clear example of how having a written policy that would tie your religious beliefs to a particular situation would have helped that school.
That's a really helpful example. Thank you, Jeremiah. Okay, so articulating with clarity in this governing document who you are, what you believe, what you're about, taking time to prayerfully sit before the Lord and develop this document. It's a discipleship opportunity. It's also square one, exhibit one, as you said, Jeremiah, in being able to lay a foundation for some of these other religious liberties. I want to move to the next topic, which is going to be employment. And so maybe this is one of the top areas where we see that operationalizing of your religious identity. So we have another poll question that's going to pop up regarding employment. Hopefully that's visible to you at this point. A candidate for an administrative role reveals they live in a way that conflicts with your church's statement of faith. Concerned about legal risk, you must decide what to do. A, hire the person anyway. Avoid the legal risk by focusing only on the applicant's professional qualifications. B, deny the application without explanation. It's the church's right to hire whoever they want. C, politely explain that your hiring policies require staff to align with your church's statement of faith and provide a copy of the signed agreement staff are required to uphold. I see some answers are already beginning to trickle in. We'll give just a couple more seconds for responses to populate here so we can gauge the results.
As those results are coming in, the one distinction that I would make, we've kind of focused the first part of the discussion on bylaws because it's such a critical aspect of the foundation of your documents. But we would say the same thing about a lot of other policies, and there are lots of ways to construct the underlying documents in your organization. So that policy, like the school in California, you may not have a policy that goes all the way back to your bylaws in that situation. But what we would say is that there's always that trail, right? Mm-hmm. So you may have a policy document related to conduct or something like that. It may not be explicitly in the bylaws document, but it's connected somewhere else. Or you may say, we as an organization need to make our beliefs understood on this particular area of doctrine or practice. And you may say, well, we don't want to put section in the bylaws. But what we're going to do is put together a theological white paper or something like that, and we're going to connect it in our universe of documents. So I want to make that clear that there are different ways to do that. It's one of the things we, as we work with churches and ministry organizations, walk through where's the best place to fit this in your ecosystem. So it's not just all this dump into this big bylaws document, but it's sort of understanding how these things work and play out in your structure.
Yeah, that's an excellent point. Thank you, Don, for that clarification. All right, it looks like the bulk of our responses have come in, and the vast majority of responses said C, politely explain that your hiring policies require staff to align with the statement of faith and provide a copy of the signed agreement staff are required to uphold. Jeremiah, I'm curious how you would answer this question, or how you would wrestle with this question.
Yeah, so it's a great question. It's one that we get all the time, and as a litigator, I kind of approach this question maybe a little bit differently than a church pastor, ministry leader might. But I'm pleased to see the answers here. I guess the first thing that comes to my mind is we advise churches and ministries all across the country. I mean, we have members all across the country, and the laws vary depending on where they are. So my first thought is, well, where is this church or ministry located? Because where they're located and the laws that might apply may affect how you respond. And so if you're in a state with very strong religious liberty protections, meaning that the employment non-discrimination law completely exempts ministries and churches from the application of that law, well, answer B might be okay. You might not face a whole lot of risk of just saying no and not explaining. But we give advice based on best practices and with the assumption of maybe the law someday might not be favorable where you're at, or maybe it's currently unfavorable. And that's where the answer C comes in as a really excellent answer, because you, right from the get-go, are telling this individual what your religious beliefs are and a basis for the decision. So if it's ever questioned later, you're not going to be in a situation where a court or your opponent is second-guessing the reason, right? So if you don't give your religious justification at the outset, it opens the door later for them to say, well, that religious reason that you're giving now after you've been sued isn't the real reason. It's a pretext for some sort of discriminatory reason. And then the other thing I just mentioned with this question, we can talk more about it, is I see that this is an admin role position. And so this would be a position that's not necessarily ministerial, and that's a legal term of art, but there's greater, broader protections for ministerial employment decisions than there are for positions that are non-ministerial. And I would assume just because it's an admin role that it likely is not ministerial, and so you're at a heightened risk here, which increases, I think, the need to articulate the religious justification for the decision.
That's great, Jeremiah. And that's actually where you're going is exactly where I want to go next. Okay. So it's hard to identify, I think, a more significant intersection between ecclesiology, then employment, that presents intersection between ecclesiology, religious mission, how a church or religious organization feels called to do what God has called it to do, plus or intersecting with legal obligations and compliance responsibilities. Employment is almost one of the quintessential examples of those two intersecting. Can you give us, at a high level, an overview of the legal concepts in play, the obligations that could be impactful, and then the religious liberties that could be available? Yeah,
so the biggest obligation, I would say, is that at the federal, state, and local level, we have non-discrimination laws, employment non-discrimination laws that prohibit discrimination based on certain protected characteristics, among them including religion. And depending on what jurisdiction you're in, and also at the federal level, there's protections for sexual orientation and gender identity, which implicate matters of religious concern. So there's an obligation of employers to not discriminate in their employment practices. Now, there's a lot of protections available too, and I would say there's kind of two buckets is how I look at it. Is there's statutory protections and there's constitutional protections for religious liberty. The statutory protections are going to vary depending on where you're located. At the federal level, Title VII applies to employers with 15 or more employees. There is a religious exemption that allows religious organizations to prefer members of their own faith in employment. Many state laws include a very similar exemption. Some state laws and some local employment non-discrimination laws exempt churches and religious organizations entirely. So there's no forbidden discrimination if you're a religious organization or church. So it's important to know what your statutory protections are. There's also within those laws what's called a bona fide occupational qualification. It's the BFOQ exemption, where the laws say that if the position, if a protected characteristic is a bona fide occupational qualification for that position, then it's exempt. Courts have generally interpreted that narrowly, but it highlights the need to explain why religion might be a bona fide occupational qualification for a particular position. Those are the statutory protections. At a high level, the constitutional protections that we look at is there's this doctrine in the law called the church autonomy doctrine. It applies more broadly than to churches. Despite its name, it applies to all religious organizations, all houses of worship, and it's rooted in the First Amendment, and actually both the Free Exercise Clause and the Establishment Clause. And what it says is that the government cannot interfere with the internal affairs or internal administration of religious organizations for matters of faith and doctrine, or in closely linked matters of internal administrative functions. So, of course, the devil is in the details when you get into litigation, but it provides broad protection for hiring practices. One component of that is the ministerial exception, which I'm sure we'll talk a little bit about. And then the other constitutional protection is we often think about the Free Exercise Clause, but there's also this concept of the right to expressive association that's also rooted in the First Amendment. And religious organizations are expressive associations. They are expressing a religious message. And so it's important to highlight that, as we talked about in your governing documents, and explain how your employees are messengers of the faith and how forcing someone who doesn't agree with the message actually infringes on the right to expressive association. So that's another avenue of potential protection.
Let's hone in a little bit. Don, did you have something you were going to add? Let's hone in a little bit on the ministerial exception. So you mentioned that the church autonomy doctrine doesn't necessarily just apply to churches. The ministerial exception is another doctrine that may be slightly misleading in its title. Who is a minister, and what's the analysis there?
Yeah, the ministerial exception doesn't apply to just like ministers as we think about it. It's a legal term. It's a term of art. And it applies to all faiths, right? And more than just priests and pastors. What the Supreme Court has said, so this is a principle that has existed in the law for many decades. And it's arisen primarily in employment discrimination lawsuits, where a church or ministry was sued for discrimination under one of these employment non-discrimination laws I was just talking about. And the church or ministry raises, hey, this is a minister. This is someone who is an important employee who's involved in the teaching of our faith or administration of some important religious function or duty. In the First Amendment, if the Free Exercise Clause means anything, it means you shouldn't be able to meddle in those decisions. You shouldn't be able to tell us who's going to lead our flock or lead our ministry. And so it's a concept that courts have recognized for many decades. But it wasn't until 2012 that the Supreme Court first had the opportunity to say, yes, that's right. The Free Exercise Clause and the Establishment Clause forbid the government from penalizing a religious organization or church for not hiring or not keeping an unwanted minister. Now, I'll go to your first question: was who's a minister, right? Who does that cover? Well, what the Supreme Court said is that, like the Supreme Court likes to do, is it says, well, here are some factors to consider. It's not a rigid test, but some things we can look at. Does the position have a ministerial title? Does the position involve some sort of formal religious training or education to be eligible to fulfill that position? Does the ministry or the employee hold themselves out to the outside world as a minister? And then lastly, what are the job duties and functions of the position? Are there religious job duties and functions? And we'll take a look at all those factors and decide whether the position is ministerial. It's not a rigid test. We look at all the factors. So that was in 2012. Since then, we've had the opportunity to litigate this issue, and another ministerial exception case made its way to the Supreme Court. And what the Supreme Court said was, yes, all those factors are relevant, but at bottom, what matters most is what the employee does. So what are the religious job duties and functions? And so we're looking at religious leaders. If you're leading a religious organization, you're a minister. If you're involved in religious, performing religious functions or religious rituals or worship services, you're a minister. Or if you serve as a messenger or teacher of the faith, you'd be a minister. And so again, it's a fact-intensive analysis, but at bottom, what's most important is what is the employee doing, what is the employee expected to do, what is the position expected to do, and that dictates whether the ministerial exception applies or not.
So Jeremiah, what about everybody else? If you go through this analysis and the employee doesn't meet what the court would consider a minister for First Amendment purposes, that's where those other statutory exemptions you were referencing earlier kick in. Talk about that a little
yes, potentially. So there is a bit of gray area in the law currently as to, okay, we have this clear principle protecting ministerial hiring decisions. It's recognized by the Supreme Court. Courts have applied it for decades. But what does that mean for a position that's not ministerial? Are you able to impose faith-based requirements for those positions? The religious exemptions that I referred to previously, they are, in our view, they're broad enough to protect those religiously based hiring decisions. Now, if you, the thing that makes the ministerial exception unique is courts won't delve into or interfere with a decision for a ministerial employee, regardless of whether the decision was based on your religious beliefs or not. They just say, we're hands off, it's a ministerial position, we're not going to touch it. Now, the religious exemption should kick in if you're making a religiously based decision for your non-ministerial employees. But if it's not religiously based, you don't have an exemption from prohibitions on disability discrimination or sex discrimination. For those employees, those prohibitions would apply, and so you need to follow them. There is a dispute in the law, though, as to whether those religious exemptions apply only to specific claims of religious discrimination or whether they would also guard against claims of, say, sex-based discrimination, so some other protected class. And this comes up in the sexual orientation, gender identity context the most often because you say you have an applicant who maybe is in a same-sex relationship and that conflicts with the church or ministry's religious beliefs about marriage and sexuality, and they could bring a religious discrimination claim, or they could bring a sex discrimination claim, or sexual orientation discrimination claims, or all three. And there's a debate going on right now as to whether religious exemption would bar all of those claims or just the religious discrimination claim.
That's really helpful summary, and I want to jump into the practical side of what do we do about it, but. If you could just real quick, you mentioned a debate going on. Can you just briefly touch on what's happening in the courts at this particular moment related to that debate?
Yeah, so what we're seeing is, again, the ministerial exception is strong, and we have clear articulations of it from the Supreme Court, about as clear as you could get from the Supreme Court. And so what we see is courts are very willing to apply the ministerial exception in cases that deserve it. So if the position does have religious job duties and functions, if it's articulated, courts seem willing to go there and to apply that exception. In fact, they seem more willing to do that than to wrestle with some of these unsettled questions as to the scope of a religious exemption, and then also the scope of if the religious exemption doesn't apply or there is no religious exemption. For instance, in some states, the religious exemption is very narrow. Does the First Amendment still kick in to protect a religiously based hiring decision for a non-ministerial employee? And so there's cases currently pending. We have one in particular at the Ninth Circuit where the court is being asked to answer that question. Does the First Amendment protect a religious organization's right to prefer members of their own faith in employment, even for non-ministerial positions? So stay tuned. We're optimistic that the court will get it right. We obviously think the First Amendment does protect that, but it remains to be seen what courts say.
So Don, what do you do with all this? Or in your mind, what is step one if you're a church or a Christian ministry trying to steward your employment documents in a way that's going to maximize your access to those arguments?
Well, yeah, and that's Jeremiah did a great job summarizing where the law is and where the law is a little gray and unclear. But it's like, well, what do we do? What do we do with this reality as we're trying to lead our organizations now? I want to go back to the question because I want to point out one thing that we didn't point out about the question that I think is important. And it says, in a way that conflicts with your church's statement of faith, which means we can infer that this potential employee knew what the statement of faith was. So that's where I want to start. That I think is a critical part of this whole process. And if you dig into some of the cases, even some of the ministerial exception cases that have been where organizations have been successfully protected, one of the contentions in those is, did the employees even know that there was a statement of faith that they were agreeing to? And some of those cases have turned on the fact that the employee just signed the document.
Yeah.
And the organization won. But I find those facts incredibly troubling.
Could I give an example?
Yeah,
so that reminded me of a case I had. It was my very first case when I started at ADF, where the facts honestly weren't great, where you had an employee who, before taking the position, told the pastor that she was in a same-sex relationship, and would that be okay? And the pastor wasn't as clear on that as he should have been. And she began working there and worked there for a couple years. And it later came out that she was publicly, and at the higher level in the denomination, they learned and they weren't happy about this situation. And so one thing led to another, and that person and their employment ended. And she filed a lawsuit, not alleging discrimination because she knew that the ministerial exception might bar that type of claim. So she said she was fraudulently induced into taking the position. I told them about my relationship. They said it'd be okay. And so I wouldn't have taken this position if it weren't okay. So not the best facts. I don't recommend that. But one of the things that really kind of helped turn the case was that the church at the denominational level had been very clear about having a statement, essentially a statement of faith, that the potential applicants and employees had to review and sign off saying that they read and understood it. And the sympathy that this person had from the other facts kind of was diminished by the fact that she had read the statement, knew that it was opposed to the church's beliefs, and signed it anyway.
Yeah, so that underscores the point. Is clarity is incredibly important, and so we don't want. You might be able to protect yourself with a signed document like that. You might be able to protect yourself in a fact-based situation like that. But a much better way to go about that is to start with the point of clarity. This is what we are as an organization. This is what we require of our employees. And this is what we make all of our employees agree to if they're going to work at this organization. We believe if you do that, despite even some of the gray areas in the law, that there should be constitutional protections available for you as an organization. Now, let me go back to another point that we've talked about, is we we think that the legal protection side of this, or I just want to be clear that we talk in legal protections. That's the language that we talk in. That is not what the reason that we do all these things.
That's right.
You don't make these choices for the purpose of legal protection. I think you can exercise wisdom to the situation that you're in that will result in greater legal protection. But the first goal in this, so talking about employment, is to be clear about where your organization stands, what your organization believes, to be able to communicate that clearly, and it to be sincere. Don't just put something in there because like, hey, we think this would help us. And so, like, you look at the job description of the pastor's administrative assistant or something like that, and it has a bunch of lines in there about preaching every Sunday or something. Well, that's not sincere. That's not what but what you can do, and I definitely recommend job descriptions being a place to capture this, is you look at all the roles in your organization, roles that maybe you don't even have right now that you might have in the future. These are the jobs and duties that need to be performed for us to move forward into the mission that God has called us to. And think about your philosophy of employment. Think about how these roles need to be aligned and on the same page. And start walking that through. And I think a really good way to start doing that is to actually put together job descriptions that include sincere duties that focus on the religious aspect of the role. So what do you require of the employee? Do you require them to be a member of the church if it's a church employee? Do you require the member to lead? Like, do you have a team leader, and are they required to lead the people they lead in prayer or in Bible study or something like that? If that's been sort of just of course we just understand that's part of the job. You work at a church. Mm-hmm. We really encourage you to put that in there. So I think that goes to clarity, but clarity and then developing, just like in the bylaws, like being sincere and writing down the mission that God has called us to in employment. It's being clear and saying this is, and being intentional about the environment we're creating for the employees.
Yeah, we can't assume that a secular court or judge understands what it means to work at a church or religious organization. And so what Donna's getting at is just help explain the reality of what is taking place within your church and ministry.
So if I could just attempt to summarize that was great. Develop a certain philosophy of employment, of what it means to be an employee of the church, and then communicate that along with what your church believes and the related expectations early in the process, and then also document it in the relevant documents like a job description. So the employee knows who you are, knows what you're about, knows what you believe, and knows what's expected of them as a result, and then have them consent to that through a process that is organized and clear. Excellent. Thank you.
Sounds good.
Yeah. All right. We're going to move on to our last formal segment here, the facility use policy. So another question is going to populate on your screen in just a second. And I do want to mention, as that question's popping up, there is that church readiness questionnaire that I mentioned at the beginning. I really encourage you to revisit that document after this seminar, after this webinar, and walk through it with your church leadership, walk through it with your church staff, and use it. Answer those questions and see if it's helping you to identify where those gaps are and where, as a church, you really need to spend some time revisiting your documents and your policies and your processes. So there's questions on that questionnaire that correspond to bylaws, employment, as well as facility use. So here's the question. A community group, and that's referring to not a small group within your church, but a group from the community wants to rent your church's space, but they do not align with your biblical beliefs. How do you respond? A, allow them to rent your space. Your church's mission is to serve everyone. B, allow them to rent the space, but only if they agree to sign a statement acknowledging and agreeing to respect your church's biblical values while in your facilities. Or C, decline the request. Your church only allows buildings to be used for mission-aligned purposes. A lot of responses are already trickling in, but I'll give just a couple more seconds for those to populate before we'll dive into it. And I'll just mention while we're waiting, facility use is a massive topic. There are so many layers and issues to discuss. We're actually having a completely separate webinar dedicated exclusively to facility use for our CMA members in about 2 weeks. So hopefully if you're a CMA member, you've already received an invitation to that. If you haven't, definitely let us know, but we encourage you to attend. That'll be an opportunity to really dive into this issue. Today we'll do our best, but we'll probably have to stay a little bit at the surface level, particularly in light of time. All right, so the answers are mostly in, and it looks like the majority of responses chose C, to decline the request. Dawn, how would you wrestle with this question, or how would you respond to this question?
Well, I would say that this is a trick question. There is not a right answer to that question, and so you could pick any one of those, and let me explain why you could pick any one of those. Just like we talked about your self-definition that happens in your bylaws, your philosophy of employment that needs to take place as you think about what employment looks like in your context. That's the same thing that needs to happen with facility use. You need to prayerfully consider this is the space that we've had. This is a gift from God that we've been given to steward, and how are we going to do that? And so we actually describe this typically in kind of 4 levels, and we have a facility use tool available to our members that kind of walks you through this. But we kind of describe it in 4 levels. And level 4 is you're open to anyone. You're open to, you feel like this building has been given to you for the broader use of the community, and that's what you're going to use it for. Level 3 is more reflective of the B answer, which is we have this space, and we want a lot of people to use it, and they don't necessarily have to agree with us, but they have to agree to respect who we are and understand where they're coming into. Level 2 is sort of the C answer, which is we only are going to allow this space to be used for mission-aligned purposes. And then level 1, which isn't really represented in the question, is, hey, this really is only for this community. It's only for the members of this church. And the reality is that's why there's not a right answer to this question. Because the important thing is that wherever your answer falls on that is that you're rooting it in your sincerely held religious beliefs. This is what we think we've been given this facility for. And think about the different kinds of facilities. It might be a different question for a chapel building, or a multi-purpose gym, or a school versus an office space. And so this is, again, another important aspect where you have to sit down and think, why were we given this space, and what does stewardship look like in our context? Now, then when you do that and you decide this is how we want to go, that's where sort of the legal risk management, other questions. Because if you're at level 4, like we talked about, and you're open to everyone, there's going to be significant more legal risk across the spectrum that you need to consider and think about. Financial risk, other things. And as you move down, I think those risks tend to mitigate a little bit, but they're different in each level. And so it's just another area of stewardship that you need to think through. And there's as many answers as there is types of organizations and types of buildings. Field space. I went to a church, and one of the things we wrestled with was we had this incredible, huge open lawn space. Didn't have a very big building, but there was this amazing thing, and the community that we lived in almost had no fields. And so we had to articulate, well, what does that look like for us to provide field space for football and soccer for the community that we live in, and articulate that according to our what we believe God had called us to as a church.
And Don, you lay that out really helpfully, which is not to say, and you alluded to some of this already, it's not to say these choices aren't without risk.
Right.
And in fact, you have to be prepared to walk through an analysis of those risks depending upon the decision you make. Jeremiah, could you highlight for us what, when we're talking about religious liberty concerns, might be the primary risk for churches in this space?
Yeah, so as you said, there's kind of gradations of risk. The important point to remember is the more open you are with your facilities, the greater risk that comes with it. That's not to say don't do it. It's just the reality of there's greater legal risk. And there's a variety of legal risks. We're going to focus on religious liberty, but there's child protection issues, there's tax implications, and so there's lots to think through. But from a religious liberty component or piece, one thing a church or ministry needs to be thinking about is every state and pretty much every major city is going to have non-discrimination laws that prohibit discrimination in places of public accommodation. So these are laws that were enacted many years ago that were typically more narrow, that applied to places like, restaurants and hotels and inns, and prohibited race-based discrimination. Over time, though, they've broadened significantly, including lots more protected characteristics, including religion, including sex, sexual orientation, gender identity, and applying to a lot more places, where essentially the definition varies depending on jurisdiction, but essentially if you are offering your goods and services to the general public, you could be considered a place of public accommodation. And so if you're opening up your facilities for rent to the general public, then there's an argument to be made that you might be a place of public accommodation. And there's religious exemptions that are available, just like there is in the employment space, but it is a risk you need to be aware of.
Now there's, as we've alluded to, all three of us, there's nuance and complexity and layers of discernment to this. But if we could just hit one piece to maybe identify for today, what would you say is the most important element for a church to include within a facility use policy in order to help mitigate some of the risks of whatever level of openness they discern?
Yeah, I would say the biggest thing is to make sure you're tying your facility usage to your statement of belief, to your religious beliefs, saying that you are stewarding and facilitating these buildings in alignment with your beliefs, that you're not going to do anything that contradicts what's in your statement of faith. That's going to make it less likely for you to be viewed as a place of public accommodation. And by explicitly tying your religious beliefs to the facility usage, you're going to be able to rightfully avail yourselves of the religious exemptions or the religious arguments that are available to you.
Thanks, Jeremiah. And I know we are running close to out of time here. There is one more topic that I didn't mention at the beginning. I think it would be meaningful to hit on it really quickly. It's been in the news over the last few months. A lot of churches have had questions about this, and that's the Johnson Amendment. Don, could you just briefly describe what the Johnson Amendment is, and then perhaps touch on some of the recent events?
Sure. The Johnson Amendment is named after President Lyndon Johnson. But before he was the president, he introduced this as a senator. He was a Texas senator. The Johnson Amendment was introduced as a amendment to a sweeping tax bill that was passed by Congress in 1954. A little brief history of how that Lyndon Johnson came to introduce that is basically in his previous election campaign, his political opponents had started nonprofit organizations, which then became weaponized and actively opposing his candidacy for the office. And so he started asking around, isn't this illegal? This shouldn't really be, and found out there wasn't actually any applicable law, and so he introduced this amendment to the tax code. And basically what it says is that an organization, otherwise an exempt organization, would lose can only maintain their tax exemption if they're an organization that does not participate in, intervene in any political campaign on behalf of or in opposition of a candidate for political office. So that's the Johnson Amendment. That's what it's becoming known as sort of this. If you're a 501c3, you've heard that description of a nonprofit. You're a 501c3 nonprofit, you can lose that status if you violate this amendment. The enforcement itself doesn't have particular, or the amendment itself doesn't have particular language related to churches and religious organizations, but it has seemed to have a pretty a larger impact on those organizations because pastors and churches advise their congregation on a variety of issues related to faith and practice, including issues that might be in an election or be related to a candidate for office. And so this is always set on the books as a challenge for pastors and churches and potentially a violation of the speech of a church. So there has been a lot of recent articles on that, and I'll let Jeremiah explain like the posture of the litigation. But there's often been efforts to overturn the Johnson Amendment, but there's been a lot of publicity recently on one in particular.
Yeah, so there was a lawsuit filed. It wasn't filed by ADF, but it was filed on behalf of the National Religious Broadcasters, as well as some churches. Recently, the reason we're seeing news about it is recently the IRS agreed to enter into a consent decree, essentially an agreement to settle the case, where they were going to agree not to enforce the Johnson Amendment against churches for in certain circumstances, essentially religious speech from the pulpit through customary channels, so not like abnormal stuff that a church would be doing. If you're through customary channels and you're talking about politics through the lens of your faith, we're not going to enforce the Johnson Amendment against you. That consent decree has not yet been approved by the court, though. There are those who are challenging whether the court should do that. And so the short answer as to what's changed, nothing's changed for churches. The Johnson Amendment is still in effect. And even if the consent decree were to be approved by the court, again, it's just a limited subset of speech coming from churches. It doesn't give you carte blanche to become a campaign organization.
And we wanted to mention it because there were lots of news articles at the time where the consent decree became public. That sort of ran with the story. And so this is him. So there should be news, hopefully maybe even before the end of the year, on where that litigation goes. But as Jeremiah said, right now we're waiting and seeing.
Yeah.
Thank you both for that clarity. That's helpful. And thank you, everyone, for joining. I just want to spend our last couple seconds noting a couple action items. If you are a Church and Ministry Alliance member, what can you do now in response to this webinar? We would strongly encourage you to check out the Religious Liberty Assessment. You can locate that on the members-only portal. It's really navigable, really easy to find, and that's a great place to start to evaluate your governing documents and then continue to work through your employment and facility use policies. For those of you who are not yet members of the Church and Ministry Alliance, thank you for joining. You should see a series of resources linked on your page. I invite you to check those out. And then if you're interested in learning more about membership, I would certainly encourage you to reach out and to do so. Thank you again so much, everyone, for joining. We hope the conversation has been meaningful and has been helpful to you. And please be assured of our prayers for your ministry. God bless.